So the framers of our Constitution were well aware of the danger of concentrated power. And so what they did is they embedded into the Constitution two key bedrock principles. One of those is federalism, the other is the separation of powers. Federalism is, of course, the idea that power is divided between states and the federal government. The second bedrock principle that the framers embedded into the Constitution is what's called the separation of powers. And I think we all know this one from grade school, right? There's three branches of government: the legislative branch, the executive branch, and the judicial branch. The legislative branch writes the laws, the executive branch enforces the laws, and then the judicial branch interprets the laws. And so what's happened over the course of time is a fourth branch of government has emerged. That fourth branch of government is known as the administrative state. And so the reason we call it a fourth branch of government is because it essentially executes all of those powers that the three branches execute. So it actually writes laws, but it doesn't call them laws, it calls them rules or regulations. It enforces those laws, and then it actually interprets those laws. And so that's what happens under Chevron deference. These agencies are being given the power to interpret the law. So Chevron deference is a legal doctrine that the Supreme Court invented in a 1984 case. In a nutshell, what the doctrine says is courts should defer to an agency's reasonable interpretation of an ambiguous statute. It means that if Congress has given an agency a power, but it's not really clear exactly what the limits of that power are, courts, instead of interpreting what the statute means, have to defer to the agency to tell the court what it means. Executive branch agencies are deciding for themselves what the left and right limits are of their own power. And so that's problematic. But it's also problematic for constitutional reasons. And so under the Constitution, branches of government cannot delegate away the power that the Constitution gives them. And that's basically what's happened through the Chevron decision, is that the judicial branch has delegated away its power to interpret laws to executive branch agencies. So typically the way Chevron deference will play out, a federal agency will take a statute that's ambiguous, and it'll use it to interpret a brand new power it's never exercised before and impose that on a small company or a small business or an individual. That individual will bring them to court and ask the courts to stop that rule from taking place because it causes them harm. The court might look at the law and actually agree this is not what the law means. However, because of Chevron deference, as long as the agency's interpretation was reasonable, the judge has to let the agency's interpretation rule the day. The second problem with Chevron deference is that it conflicts with a federal law known as the Administrative Procedure Act. And so under that federal law, Congress explicitly stated that the power belongs to the judiciary to interpret statutory provisions. And so what Chevron does is says that no, when Congress puts forward a statute and it's ambiguous, Congress did that because it intends for federal agencies to decide that ambiguity. But if that was the case, why did Congress go through the trouble of explicitly stating in the Administrative Procedure Act that that responsibility would fall to the judiciary? And that's to say what the law is. So the Loper Bright case and a companion case both involve a challenge to a rule issued by a federal government agency that requires certain fishing vessels to cover the costs of having federal government observers ride on the boat to ensure the vessel and those operating it follow government-imposed regulations. So not only are these small businesses forced to allow these government observers onto their fishing vessels to watch their every move, but they actually have to pay for it. Even though the agency's new rule imposes tremendous costs on these small fishing vessels, because the statutory language is ambiguous, both lower federal courts upheld the rule after granting the agency Chevron deference. So now the plaintiffs are challenging at the Supreme Court not only the burdensome rule, but the doctrine of Chevron itself. So creating so much regulation also creates a lot of costs for businesses and consumers. In 2021, federal taxpayers spent more than $80 billion to allow federal agencies to develop, administer, and enforce all those federal regulations. Americans spend more than 10 billion hours every year on regulatory compliance paperwork, at a cost of over $140 billion. Another problem with Chevron is it's actually weakened Congress. It has encouraged Congress to pass ambiguous open-ended statutes and punt hard political questions to federal executive agencies. And now that may benefit some members of Congress, so they don't have to make hard political decisions and face repercussions from voters, but it hurts the American people in the process. Voters can't go to the polls if they're unhappy with these rules and vote that person out of office, because the person making these rules is an unelected bureaucrat in a federal executive branch agency. So in the wake of this decision, there are a number of things that Congress can do to help rein in the administrative state. The first and most important thing Congress can do is pass the Reins Act. And so the Reins Act is the regulations from the executive in need of scrutiny. If an executive branch tries to pass a rule that is extremely expensive and costly, Congress needs to approve that. Another thing Congress could do is go in and look at past regulations that have been passed based on Chevron deference and take another look at those same rules and remove them so that they rein in the administrative state. And so a couple examples are President Biden's unilateral increase of food stamps. Or another example is President Biden's unilateral cancellation of student loans. In the wake of this decision, this should motivate Congress and empower Congress to come in and pass new laws to strike down these regulations. And then the third thing Congress can do is go in and look at the statutes that actually outline the power of the agencies, and where those statutes have ambiguous language, Congress can come in and tighten up that language and make more clear what the left and right limits are of these federal agencies. So think agencies like the Environmental Protection Agency, the Federal Trade Commission. And so this would be an opportunity for Congress to come in and help rein that effort in by just identifying ambiguous statutes and making them more clear. So the key here is passing law is incredibly difficult, but it's supposed to be difficult. And so what happens is if it's too easy for a federal agency to create a new sweeping regulation that impacts millions of people across the country, then they're going to do that without thinking through the process the way it would in Congress. That's actually one of the beauties of our system of government, is that there is debate and there is back and forth, and that it's really hard for federal Congress and the federal government to pass laws that impact the lives of millions of people. Getting rid of Chevron deference, it is going to make it a lot harder for federal executive branch political appointees to use their federal agency to try to pursue their own political goals and ambitions. This isn't stopping federal executive branch agencies from ever passing rules. This isn't stopping Congress from delegating powers that the Constitution allows Congress to delegate to agencies. That's not being stopped by this either. What this is stopping is the judiciary from delegating away judicial power. Executive branch agencies still have the ability to use their expertise to administer the laws the way Congress intended them to do so.